If you're pregnant and working in California, you have rights, important ones that protect both your health and your job. But many employees aren't fully aware of what those rights are or how to use them. In this video, I'm going to walk you through the basics of pregnancy leave so you can make informed decisions and protect yourself during this critical time. Let's begin with one of the most common questions. Can you lose your job for taking pregnancy leave? The short answer is no. California law provides strong protections for employees who need time off due to pregnancy, childbirth, or related medical conditions. There are two main laws to understand: Pregnancy Disability Leave, PDL, and the California Family Rights Act, CFRA. Let's start with pregnancy disability leave. PDL applies if your employer has 5 or more employees. If your doctor says you're unable to work due to pregnancy or a related condition, you're entitled to up to 4 months of job protected leave. This can be taken before or after your baby is born, depending on what your doctor recommends. PDL covers things like severe morning sickness, doctor ordered bed rest, childbirth recovery, and even postnatal conditions like postpartum depression. You don't have to take all 4 months at once. It can be spread out if medically necessary. Now, here's where CFRA comes in. After your pregnancy disability leave ends, CFRA allows you to take an additional 12 weeks of bonding time with your newborn. This applies if you've been with your employer for at least a year and worked at least 1,250 hours during that time. So when combined, some employees are eligible for up to 7 months of protected leave, 4 months of PDL, and 12 weeks of CFRA. And remember, during this time, your employer is required to maintain your health benefits just as if you were still working. And when you return, they must reinstate you to your same job or a comparable one. What if your employer refuses your request for leave or punishes you for taking it? That's where the law is on your side. Retaliation, demotion, pay cuts, or termination tied to pregnancy leave can all be grounds for legal action. These protections apply regardless of whether your pregnancy was planned or not, and they apply to all eligible employees, regardless of gender, when it comes to bonding leave. Let's go over some actionable tips if you're planning to take pregnancy leave. Talk to your doctor and get documentation. You'll need medical certification to take PDL. Notify your employer in writing at least 30 days in advance when possible. Keep records of your communication with HR or supervisors, just in case any problems arise. Apply for benefits. California offers state disability insurance, SDI, while you're on PDL and paid family leave, PFL, while on bonding leave. And if your employer pushes back, or if you feel pressured, excluded, or retaliated against for asserting your rights, it's time to speak with a legal professional. Pregnancy should be a time of planning, not stress. You shouldn't have to choose between your job and your health, or your baby. California law exists to protect that balance. If you have questions about your pregnancy leave rights or believe they've been violated, visit our website at employeelawgroup.com to schedule a confidential consultation. We're here to help you stand up for what's fair and legal. You don't have to go through it alone.